Good afternoon, everybody, and welcome to the Appellate Division First Department. Nice to see you all here. We have over 6 hours of oral argument time scheduled, so we have to ask you to please ask only for the time that you really need. Please remember that we have had your briefs and your records and had an opportunity to review these cases, so just take the time you really need to tell us the important points in your case. In case you haven't been here before, when the white light goes on, you have 2 more minutes. When the red light goes on, you should finish up your sentence or your thought and stop. If we have additional questions, we will continue to ask you questions, but you're supposed to stop when the red light comes on. So let me call the calendar. The first case is People versus James Bonilla. And both sides, please stand up and let me know how much time you need. Appellant?
7 minutes and 1.
Responding?
7 as well.
Okay, well, I'm going to do 6 and 1 and 6. If we have more questions, we'll be happy to ask them. GLCA Securities versus Guards Holdings.
For the appellant, 5 and 2, Your Honor.
Okay, for the respondent? Okay, 5, 2, and 6. Thank you. E. Kendra versus Jared T. That's submitted. Langbert versus Akonsky. Also submitted. Innovative Concepts versus A.L. Infinity.
Griffin, the defendant,
The respondent's not here?
No, I'm the respondent. I apologize.
Oh.
I received an email a bit ago from the appellant saying it would be maybe 5 minutes later.
Okay, he's not here yet? Okay, I'll call it at the end of the calendar, okay? So that you can tell me how much time each of you, okay? Thank you. Cruz versus Ajim. 3 and 1. Is the respondent here? Okay, and you can get it. Manganiello versus Vitanza. Okay, thank you. People versus Oquendo is marked submitted. Modziak versus State University of New York. Appellant? Okay, thank you. Rivera versus 98-100 Avenue C. Is the appellant here? Okay, do you still want to argue? Okay, thank you very much. We'll mark it submitted. Hartley versus Burnside Housing. Okay, thank you both. People versus Hayworth. Respondent? Okay, thank you very much. Ma versus Griffin. Okay, thank you both very much. 5, 2, and 5. Sloan versus Lawrence Nursing Care.
I'm here for the appellant. I'm going to 7 and 2, please.
Okay, thank you. 419 BR Partners versus Zabar. Okay, thank you. And Lopez versus Bronx Ford is submitted. Now, did anybody come in on Innovative Concepts versus AL Affinity? Well, I'll give it 5, 2, and 5, okay? And you can let them know. Hopefully, they'll be here by the time we call the case. Otherwise, you can have a minute or two and we'll be submitted on their side, okay? Thank you. The first case for argument, People versus Bonilla.
May it please the court, my name is Paul Wiener, appearing for Appellant James Bonilla. First of all, the purported waiver of appeal is invalid for numerous reasons. The court never explained that the appeal was separate and distinct from the rights automatically waived, forfeited.
Do you have a problem with the written waiver?
No, Your Honor, because first of all, well, the written waiver I think was problematic because, well, first of all, it's not.
You think it's problematic because the oral waiver was no good, but if the oral waiver had been good, you wouldn't have a problem with the written waiver.
Actually, in this particular case, I would, because the court didn't communicate with the defendant at all about the written waiver. He never even asked him whether he had discussed it with his lawyer. He didn't ask him whether he read it or understood it. So there was nothing there.
It seems to me that's part of the oral waiver. I mean, he signed the written waiver, did he not?
He signed it, but I've cited cases.
You don't have a problem with the contents of the written waiver?
Not
Accurate to say?
Not the contents of the written waiver, but again, I think the court has an obligation to at least confirm that he's discussed it with his lawyer and so on. And the oral waiver here was extremely problematic. He incorrectly said that the plea and sentence was final when that's simply not correct. When you retain several issues, even if you waive your right to appeal, the judge incorrectly said that normally probation is 5 years, and that's incorrect. It could be 3, 4, or 5 years. He didn't explain that he was giving up the hotly contested issues in this case regarding the denial of the suppression hearing with a motion to controvert the search warrant. The oral waiver was completely problematic, and again, Your Honor, the court didn't even confirm and with the defendant that he had at least discussed it and understood the written waiver. Going on to the merits, the summary denial of...
In terms of the waiver, are you familiar with what because the people seem to place quite a bit of reliance upon this, People versus Ramos, what the oral waiver was like in that case?
I'm sorry, say that again, Your Honor?
People versus Ramos, which the people seem to place considerable reliance upon, the Court of Appeals decision, 7 New York 3rd. Are you familiar with what the oral waiver was like in that case?
I don't know exactly what the oral waiver was like in that case, Your Honor, but in this case, it was so problematic in so many levels. There were so many misstatements of the law. You know, and the idea that the court...
Well, there's no question it was brief.
I'm sorry, Your Honor?
I said there's no question it was brief.
It was...
There's no question that the oral waiver was brief.
Yes, Your Honor.
Yeah.
Yes, Your Honor. But again, the oral waiver here was so problematic, misstatements, not making it clear that he was... that there were distinct and separate, that he was giving up distinct and separate rights, and so on. In terms of the merits, the summary denial of the MAP Dunaway hearing was error here. In the omnibus motion, counsel explained that appellant couldn't say any more to controvert the allegations because he was not given any information about the basis for the search. This is just like Esperanza, where this court found... Yes, Your Honor.
Esperanza involved, I believe, the mother or grandmother of the real target here, although she got caught up in the net.
Yes.
Whereas your client was who they were actually looking for, or looking at the car and the sale. Very different case. Esperanza involved a resident who was blind, among other deficiencies in that regard. So you recognize it's not quite like Esperanza.
I do understand that. There were certainly factual differences. I think where it's similar is that in both cases, the defendant was not given any information about the crime and the arrest. And specifically, I would like to point out in Esperanza that this court says that that information was not available to the defendant at the time of the motion. And the court was quoting
Counsel, in this case, however, isn't it the case that at some point the defendant received a redacted copy of the search warrant, and after receiving that information, the defendant failed to renew his application for a hearing based on the additional information?
That's true, Your Honor. Several weeks later, he did in fact receive the redacted affidavit. However, again, as the Court of Appeals said in Hightower, and as this court quoted in Esperanza, you have to look at the information that's available at the time that the motion was made. There's a procedure here, an established procedure. You look at the pleadings, you look at the face of the pleadings, you look at the information that the defendant had at the time that the motion was made.
Counsel, that's true at the time that the motion was made. But once the defendant comes into possession of new information, why not move to renew?
I think it's just very, very clear based on what the Court of Appeals said in Hightower that you look at this, Mendoza, there's a certain procedure, and you look at it at the time that the motion was made. The Court of Appeals has said that, this court has said that, and I don't think we could start getting away from that. Finally, I'd just like to say that, if I may have,
Yeah, I have a few seconds to finish.
Okay,
your
great.
last
Just
thought.
in terms of the denial of the motion to controvert the search warrant, the only basis for the court's decision was that appellant had not addressed standing. The court was clearly wrong. Counsel did address that in his omnibus motion. He incorporated that into his motion to controvert. Everybody concedes that the defendant had standing here. The DA is arguing that the redacted affidavit provided probable cause. However, that argument is precluded by LaFontaine because this court can only address errors that may have adversely affected appellant. And here the only issue that was decided adversely to him was standing, not the alternative ground of probable cause. Thank you so much.
Okay, thank you. We'll hear from the respondent.
Good afternoon, and may it please the court. David Gagne for the people.
Counsel, I'm going to read to you a part of the colloquy that happened between the court and defendant with regards to the waiver right to appeal. So I'm going to start off with the last sentence in this paragraph, which the court says, so in exchange for that benefit, you are agreeing to give up your right to appeal. Do you understand that? Defendant, yes. The court, that means that this plea of guilty and the sentence will be final. Do you understand that? Defendant, yes. That statement by the court that this plea of guilty and sentence means that this will be final, is that an accurate statement of law?
Your Honor, it was an ambiguous and what the Court of Appeals.
It's wrong, isn't it?
It's not factually correct. Yes, because there are issues that survive an appeal waiver.
And then the court went on, it compounded its error by saying, is that what you wish to do, to waive your right to appeal and your other rights, thereby conflating the right to appeal versus other trial rights?
Your Honor, I don't believe that the plea court conflated those rights. The court specifically.
Would you agree that the waiver of right to appeal, the function that it serves is to, at best, supplement the oral colloquy? The written waiver cannot correct misstatements of law in the oral colloquy. Do you agree with that statement?
Your Honor, the written waiver may cure any ambiguities, and that's
ambiguities, not misstatements of law.
That's correct. And this court and the Court of Appeals, specifically in Bradshaw, said that when a court says that the sentence is final, then that is the type of ambiguous remark that can be cured by a written waiver. And that's exactly the function that the written waiver had in this case, because in the written waiver, it did state that there are certain issues that will survive even a waiver of appeal, and it enumerated those issues.
Do you concede that with regards to the written waiver, the court did nothing to elicit from the defendant whether he had read the waiver, whether he understood the waiver, whether he had any questions about the waiver? Do you agree with that proposition?
I don't, Your Honor, and
What did the court do?
I'll explain why. The court asked defense counsel whether there was a waiver of appeal in this case. Defense counsel said yes. Then the court asked whether that waiver of appeal was acceptable to the defendant. Defense counsel again said yes. And at that point, there had been no waiver colloquy. There had been nothing orally on the record. So this was clearly in reference to the written waiver that both defendant and his counsel had already signed. That's really the only fair interpretation.
Couldn't that have been to the fact that a waiver was being required by the people? It had to have been. So your inference is that that line of questioning went to the written waiver.
Yes, Your Honor. And the very next question that the court asked of defense counsel is, did he sign one? Did he sign the written waiver? So it's pretty clear that the court inferred that what they were talking about when they were talking about the waiver of appeal was what had already taken place, which was the written waiver that
Right, but this colloquy is not for the benefit of the court, right? It's for the benefit of the defendant. So why would the court infer such a thing without asking?
Well, perhaps it could have asked, but I think it was a fair interpretation for the court to make that it had communicated with defense counsel that they had reviewed the written waiver and that the defendant didn't have any problems with it, and he in fact said it was acceptable.
In this oral colloquy, does the court at any point make inform the defendant that the rights that he's waiving, the appeal rights, are separate and distinct from the trial rights?
They never state that specifically. Of course, that's never been a specific requirement. There is no particular litany that must be stated. There are no magic words.
So you cite to People versus Ramos, which is a very brief Court of Appeals decision. Do you recall what the ambiguity that the Court of Appeals refers to in the oral waiver was like?
Yes, Your Honor. The ambiguity was, if I'm remembering correctly, that the judge said, this is final. Your sentence and conviction is final. That's exactly what happened in this case. So that's precisely the type of ambiguity that can be cured by the written waiver, which did, again, enumerate the issues that will survive even a written waiver.
Did that case involve the conflating of the rights, the trial rights and the appeal rights?
Your Honor, I don't believe that this case did. I don't.
That's not my question. My question is was that the case in Ramos?
The case in Ramos was that it was a very perfunctory oral colloquy. That was the words that Bradshaw used to characterize the oral colloquy in Ramos.
That's certainly true here, too, that this was a perfunctory oral waiver. So
No.
cite to Ramos, which seems to give a pass to that perfunctory waiver. The question is what the perfunctory waiver there is in comparison to the perfunctory waiver here.
Well, Your Honor, I don't believe that there was a perfunctory oral colloquy here. The court did explain to defendant that he was waiving his right to appeal as part of a negotiated plea bargain, that he was getting a very favorable sentence as a result. And he did, in fact, get a very generous sentence. He received just 3 years of probation when he faced up to 9 years in state prison.
Just with regards to the standing issue, are you conceding that the lower court got that wrong?
The lower court overlooked the standing argument and if I may just finish my...
It wasn't overlooked. The lower court said he didn't have standing.
It said that he had never addressed that issue. So they overlooked the standing argument that the defendant didn't raise in his motion to controvert the search warrant, but that he had incorporated from his previous omnibus motion.
And was that enough to establish standing?
We're not arguing that there wasn't enough to show standing, Your Honor, but we are saying that there was probable cause was made out in the search warrant affidavit.
In light of LaFontaine, is that something that's properly before us?
Your Honor, I don't believe that LaFontaine would apply here. As a Court of Appeals stated in People v. Garrett footnote 2, where there are multiple components to a legal ruling, an appellate court may review other components that were not considered by the court below. So for example, in People v. Wahab, the trial court denied the suppression motion on the basis that there was no standing. The Second Department nonetheless found that there was standing, but affirmed the conviction on the basis that there was probable cause made out in the search warrant affidavit. And that's exactly what we have before us here.
If we were to find that the waiver was no good, And in light of what you have to say about standing, how do you get to an affirmance here from your point of view?
Well, I think there are two ways that there could still be deferments, even if the waiver was invalid. One, the defense did not preserve the argument regarding the motion to controvert the search warrant. There was 3 months that passed between when the motion was decided and when defendant pled guilty. At no point during that time did defense raise any argument. Did they file a motion to renew the argument that the court had simply overlooked the standing issue? It would have been very simple. They didn't do that, and now, more than 6 years later, they asked to send this case back, and they asked for a Darden hearing, knowing full well that that would require the people to produce a confidential informant 6 years after the fact. And that's, honestly, that's a form of gamesmanship that the defense is playing. Rather than bringing it to the trial court's attention at the time the error occurred, they're now doing it 6 years later when it's clearly prejudicial to the people.
Okay, thank you, counsel. Appellant, you have 1 minute to respond.
Just a couple things. First of all, in terms of the waiver, I just want to point out on page 20 of my brief, I've cited a couple Court of Appeals cases, Green and Lang. In those cases, the Court of Appeals found purported waivers invalid where the lower courts erroneously stated that once the defendant was convicted and sentenced, there will be no review by any other court. And in Bassano, it invalidated the purported waiver where the written waiver forms indicated that the waiver was an absolute bar to direct appeal, which is very similar to what we have here. I just want to also point out that in LaFontaine, People v. LaFontaine itself, the people were, in that case, trying to raise a different theory for suppression, and the Court of Appeals said no, that wasn't, they can only raise a theory that's adverse to the defendant. And so I'd urge you to just look at LaFontaine itself. And finally, the standing issue was...
They said you can only look at something that was decided adversely, not just is adverse, but it has to have been decided adversely.
Yes, Your Honor, exactly. And then, I mean, the standing issue was preserved. Counsel made all the arguments. He incorporated it, and it was clearly...
What about your failure to renew the request?
I mean, again, I don't, you know, he did everything, you know, I don't think there's an obligation to renew the request. He made the arguments, he incorporated his motion. And I would also point out that these were both all before the same judge. You know, it was not like even a different judge here. Thank you so much.
Thank you both. The next case for argument, GLCA Securities versus Guards Holdings.
May it please the court, John Brewer from Amini LLC for the appellant GLC. From Amini LLC for the appellant GLC. As we set forth in our briefing, this is a straightforward breach of contract claim that should not have been dismissed on the face of the pleadings. The really sole question to be adjudicated is a fact-intensive one. It's whether the transaction, the small t transaction that the defendant entered into was a capital T transaction within the meaning of its contract with its financial advisor, my client, that entitles my client to a fee.
So Judge Schechter found that it was very clear and that this did not come within that this particular transaction.
She said that. The interesting thing, Your Honor, is she gave, it's very short, she didn't cite any cases. She gave two reasons, neither of which my colleague is actually willing in his appeal brief to defend as based on a correct statement of law.
I don't know whether that's fair enough, because what's your response to what seems to be a central point of the respondents is that they make the analogy that if the owner of a fleet of 40 food trucks sell 3 of the trucks to a different operator, together with the licenses, permits, and supply contracts needed to run those 3 food trucks as a business, that clearly is not in the language that we're dealing with here, a business combination by which the business of the buyer is combined with that of the third party. Why isn't that an apt analogy here as to what your position is?
Because according to their own contract with their seller, they bought a, quote, business entity, close quote, and they bought the complete business entity. That's on, I think, page 63 of the record. It wasn't just a food truck. They bought, this is a gas production field up in Alaska.
This is a lease.
It's the leases, it's the sale contracts, it's the pipelines, it's the equipment. They represented to the state regulators that they were going to run the business in exactly the same way with the same personnel.
The defendant existed before and the defendant exists after. Isn't that so?
Okay. What they're saying is, I think their new argument, they gave up on the two things. Having given up on the argument that something structured as an asset sale rather than an equity sale can't possibly be a business combination, they're now saying, I think what Your Honor is getting to, they're trying to read it as saying, in order to be a business combination, the business acquired had to be 100% of everything the seller owned. Here, the seller owned.
Well, the contract itself says, the agreement, it says a combination pursuant to which the business of GHI is combined with that of a third party, a purchaser. And you don't have a combination of businesses. The business existed before, and the business exists afterwards.
Well, I would say there's nothing in this record actually as to what, if any, assets the seller retained. They may have retained some. Somewhere else, I believe they had some other gas operations in some different part of Alaska they may have retained. But this was a fully integrated, standalone business. They bought the entire business, and they also bought the entire business. They also bought, as we said, the entire equity of Anchor Point Energy LLC.
This comes down, does it not, to what business combination means?
It does. And business combination here.
And is that not defined?
It's not defined in statute, where it's surprisingly undefined in case law. It's a common term in the relevant business. Here it's used as a catch-all. It's, A, B, C, D, or any other business combinations. It's obviously intended to be a broad catch-all.
Does it make any difference that the one company that they bought, the APE, I think is APE?
Yes.
That was a very small portion of this. At least it was structured that this was worth very little compared to the full.
That was the allocation. I mean, this is the entity that owned the entire pipeline. It's important enough that it's a regulated entity. You have to do all these regulatory filings in order for the Alaska bureaucrats to approve the change of control. They did an allocation for tax or accounting purposes that assigned a very small portion of the consideration to it. I doubt that, maybe it was, I don't know, $10,000. I doubt $10,000 is the fair market value of 10 miles of pipeline.
So what is it that we should look to figure out how to understand or interpret the term business combination in this context?
I think what it is it's a term that has meaning in the relevant trade. And there'll be discovery on remand. If need be, we can have an industry custom and practice expert say, what do people mean by business combination among mergers and acquisitions professionals? And that's related to, if I could just finish this one sentence, that's related to the point of what's commercially reasonable. That people do deals like this all the time where they buy, one division of a business, one product line, et cetera, et cetera. And when they do that, usually their financial advisors get paid.
Okay, you'll have a couple minutes to respond. Let's hear from the respondent.
Good afternoon. May it please the court. Stuart Reback from Wilk Oslander for the respondent.
So if you could just clear up, because I think some point is being made out of this about what happens to Anchor Point, which had a $1,000 valuation on it. Is that correct? So that sort of disappears, doesn't it? Where does Anchor Point fit into this dispute?
Anchor Point is an entity that owns the pipelines that service. So
how did the value, I'm sorry to interrupt, but how did the valuation get determined? That was you put the evaluation on that that part of the transaction was only worth $1,000?
I'm assuming that was negotiated between the parties, but there's a couple of other things that indicate why Anchor Point is just part of the North Fork unit, and it's not a separate business. If you look at section 1.2F on page 40 of the record, you'll see that pipelines, and there are all the pipelines which are shown in Exhibit K, which is the assets of Anchor Point. Pipelines are part of the properties, capital P properties, which are being conveyed. That's what the North Fork unit is. If you look at the definition in the very first paragraph of the purchase and sale agreement on page 35 of the record, CIE is defined as both Cook Inlet Energy, which was the active counterparty on the sale, but it's defined as Cook Inlet Energy and the combination of Cook Inlet Energy and Anchor Point. So it's indicating the Cook Inlet, which is the entity that actually owned the leases. It's the subsidiary of Glacier, which the complaint alleges accurately was the actual counterparty. The Cook Inlet is the real actor here. So the bottom line here is that the lower court got it exactly right. This isn't a business combination under strict application or under very unremarkable application of a justum generis.
So this goes to the fact that the term used is business combination, and, you know, it would seem you've got a decent argument as to that. The business existed before and the business existed after on both sides, so you don't have a business combination. But what do you have to say in that very same provision, letter I, it's on page 19 of the record, I believe. It says, part of that definition, any merger, consolidation, joint venture, scheme of arrangement. Scheme of arrangement seems to be this really broad, open-ended sort of term, which could mean anything.
Well, I looked at the case law to see what a scheme of arrangement is, and I saw that it refers to two different kinds of things. One is something under British law where, similar to what happens here, where you can purchase an entire business out of a Chapter 11, you buy all the assets of the business as part of an insolvency proceeding, and the other one was a workout of debt, which under the terms of the particular GLC agreement would be a financing rather than an M&A. But just as a matter of justum generis, it's other business combination. It has to be a combination. It has to look something like a merger or a consolidation.
There's a business combination.
It's an other business combination. In other words, under a justum generis, when you have the catch-all, it has to look something like the things that preceded it.
But, I mean, is that so clear that we can make that determination on a motion to dismiss as opposed to allow some discovery and listen to some testimony about the custom and practice in the business?
Sure, because the words business combination don't appear alone. The words business combination say it's a business combination by which the business of Gardus is combined with the business of another party. That's what the agreement is. It tells you what a business combination is. There's no way to read this. There's no allegation in the complaint, for example, and it couldn't be because it's not true, that the seller went away after the transaction.
Could you address the declaratory judgment, which is part of your counterclaim, which is also on this appeal?
Sure.
And why is that not an advisory opinion to say that it won't include this or it will include this? Hasn't the time that this agreement covers your actions expired by now?
No, it has not yet expired, and the GLC agreement provides that the tail applies if there is, I believe it's a letter of intent that's entered into ahead of time. So if there's a letter of intent that's entered into and the closing comes in after the tail, there still can be a claim for a fee. But the reason that it's not advisory is there's any number of cases, and I'll just start with M&A Oasis against MTM, where the plaintiff wanted a declaration that he had a right of first refusal on a property, and the defendant said, there's no offer on this property yet. Why do you need a right of first refusal? This is advisory. And this court said, no, it affects, you have no control over whether a third party makes an offer, but you defendant, do have control over how you react in the event that there is an offer. This will affect how the parties deal with each other going forward, and therefore you're entitled to a declaration. I think that's more or less on point with this. There's, in Mr. Gardis's reply affidavit, he sets forth two particular transactions, both of which had to go by the wayside. In the one case, because they were unable to do the economic analysis in order to see whether it made sense, and in the other case, because the possibility of a claim made it uneconomical to go ahead with the transaction. Thank you, Your Honors.
Okay, thank you. We'll hear from the appellant. You have 2 minutes.
Thank you, Your Honor. Just quickly, let me get back to the contract briefly, and then I'll try to briefly address the declaratory judgment points.
Thank you.
Again, the argument that they've got at this point, having abandoned the arguments they went on below, is that you have to acquire business combination means not only a combination with a business you buy, but with the entirety of everything the seller owns. And here, the seller owned a business entity, standalone, fully integrated operating business entity that it sold lock, stock, and barrel to GHI. And they're trying to read in a word like entire, that it's whereby it's combined with the entire business or all businesses. Again, it's like Warren Buffett's company owns an insurance company and it owns a candy company. And so their theory would be, well, if you buy the candy company without buying the insurance company, that's not a business combination. And that's, I think, sufficiently in tension with common practice in the M&A world that we're at least entitled to some factual development. Separately, I would say, again,
Sorry, in buying the business of APE that you claim they did they get the liabilities of that company?
They bought the company. It's an LLC. They bought all the equity of the LLC. So if the LLC had liabilities, they have those liabilities, as far as I know. I don't know what its balance sheet looked like, but again, they're trying to say, oh, that was just a shell. It wasn't a real business. It didn't have a business of its own. That's a business. It's a regulated pipeline operator. That was the only piece of the business where you had to get regulatory approval. I'm sorry, Your Honor.
They become the employers of those people operating the pipeline? If not, it's my understanding that there was a transitional contract.
There was a transitional.
Wait, let him finish.
Sorry.
Sure.
I apologize.
Yes.
Where certain services were provided by a transitional agreement, like we're giving you help along this process. They didn't become the new employers of any of APE's employees.
Okay, in the application, and I can give you a record site if you give me a minute. There's two stages. There was this transitional period where they were using the old owner was continuing to run the thing because the buyer had not yet gotten regulatory approval.
But that was from from the Cook company, not from APE. You were focused on APE being bought lock, stock, and barrel.
Okay, here's what I'd like to focus Your Honor on. This is on page 237 of the record. And this is in the joint application to the Alaska State regulators. And this is talking about after they get approval and after GHI becomes the operator. They say, in addition, GHI intends to retain key CIE and/or APE personnel, as well as maintain current APE contractors that support NFP operations. And there's no dispute that, APE, Anchor Point, has no separate continuing business. It is owned 100%, combined 100% with GHI. The red light's on. I'm happy to talk briefly about the declaratory judgment if you want me to.
Well, I'm going to, we have your briefs and we saw your arguments on that, so I think
The point there is, I guess the only point there is, there's six weeks left, I believe. It's 6 weeks left before the tail period goes poof, and they have not made a motion in the court below for any relief.
Thank you. Thank you both. Do we now have both attorneys on Innovative Concepts versus AL Infinity?
Yes, sir. Yeah.
Okay. put your stuff down there and then take what you need to the podium in the center. And in the future, you should be here on time. Your adversary was kind enough to let us know, you said you were gonna be late, but you're not supposed to be late. So I gave you the extra time, not everybody will do that. All right, so why don't you go to the center, and we've given you 5 minutes and 2 in rebuttal, okay?
Thank you, Ron.
Welcome.
Would it be okay if I just took some water? My throat is dry.
Yep. Okay, you may proceed.
Good afternoon, Your Honors. My name is Jerry Grunsfeld for the Plaintiff Appellate with the Law Office of Lazar, Grunsfeld, Elmendorf. The reason for this appeal is there had been 2 trial court decisions where the court, excuse me, where the court had cited the case of Schatz v. Shertok, the First Department case, and the court had cited that the reason why the court was granting the defendant's motion to dismiss is because the plaintiff's pleadings and the evidence plaintiff had brought on its first motion to renew of a breach of contract was lacking because any allegations of breach of abuse of discretion had failed to show that that abuse of discretion was motivated by self-enrichment. And the trial court found that the Schatz v. Shertok precedent required allegations of abuse of discretion to show that the motivation for that abuse was self-enrichment. Subsequent to that, the defendant, AL Infinity, had filed their own case against my client Gemini, and during the course of discovery, in that case, we had obtained documents which very clearly showed that Infinity had abused its discretion, and critically, that the abuse of that discretion was motivated by self-enrichment.
But when you entered into this contract with the defendant, you knew about Sakar, you knew about that company.
Yes,
you
Your
knew
Honor.
about that other license agreement, and I
Yes, Your
assume
Honor.
you also knew that they were a larger license than your
Yes.
license, and yet
Yes.
you entered into an agreement that gave the defendant unfettered discretion to
Right.
make determinations if you disagreed. So couldn't you have you protected yourself in that agreement so that we didn't ever get to this point?
Right. What my client didn't know was that Sakar had sent emails to Infinity, the defendant, stating that if you do not give the rights to my client's best-selling speaker, if you don't turn those over to us, we're not going to renew our license agreement. How can my client have ever foreseen something?
Is that really such a matter of renewal? You know that there is this dispute with Sakar. You know that Sakar, you've got to know that Sakar is a much bigger customer than you are, so that Sakar is going to be taking the position, look, if you don't see this our way, we may walk. It's not exactly a startling piece of information.
What's startling is that Sakar said, if you don't take a speaker that Gemini is already producing and is
If you don't see it our way, we're going to walk away from you.
It's not that if you don't see it our way, it's if you don't turn over the rights to another licensee speaker and give it to us.
Which they're claiming, right? They're claiming that they should have the right to that speaker.
Right.
That's the dispute. Does Sakar have it, or does Innovative Concepts Gemini have it?
Right. So we're alleging that it was an abuse of their discretion to take my client's speaker and turn it over to them solely because they were threatening not to renew their license. And the proof that this wasn't just a regular business decision is that they wrote about it in Sakar's license renewal agreement, but they wrote nothing about it in Gemini's license renewal agreement. If this was an above-board business decision, then the first place they would write about it would be in Gemini's license renewal agreement. They would say, listen, we're renewing your license, but understand you're not getting the X4 anymore because it's going to Sakar. They didn't do that. They wrote it in Sakar's. And the same with these minimum speaker size dimensions.
I mean, didn't this very agreement, by its leaving sole discretion with Infinity, always expose you to this sort of outcome.
Well, Your Honor, the
It's not a
Shatsky...
matter of, you left it to their sole discretion. There's no provision that we're going to, it's not your discretion, but we'll go to arbitration, we'll go to court. You sort of put yourself at their mercy, and they didn't turn out to be very merciful.
Your Honor, you could make that argument against any of the cases that follow the Schatz v. Sherdock precedent, and there's hundreds of them. The case law says that, yes, even a party that has sole discretion can't abuse that discretion in order to enrich itself. And we uncovered documents that showed that's exactly what...
Is it enriching itself when it gives SACAR this benefit?
Yes, it was enriching itself because they only gave SACAR that benefit in order to ensure, A, that SACAR renewed its license, and B, they flagrantly breached the license agreement, which required them to give Gemini a 120-day
But in terms of what they're selling, they get the same fees whether those speakers are being sold by SACAR or whether they're being sold by Innovative.
No, but Your Honor, they were most keen to ensure that SACAR renewed its license agreement.
Because
SACAR,
they were going to get a lot more money from
right,
SACAR than from you.
something like tenfold. SACAR was
They're a bigger customer.
way bigger. They were tenfold bigger licensee, but that doesn't give them the right to trample over a smaller licensee. For example, if SACAR had
All right,
said...
well, I'll tell you, give us that example on rebuttal if you don't mind, okay? Thank you. We're going to hear from the respondent, and we'll let you
Thank you, Your Honor.
have a few minutes.
Good afternoon. May it please the court.
So how does this, this arrangement here and the claims here differ from the Schatz versus Chertok case? I mean, there was also unfettered discretion, but the court, some of us being on that court, said the complaint sufficiently alleges that they exercise, meaning the defendant exercised their discretion in bad faith and to self-deal. How is that not exactly what happened here?
There's no self-dealing here, and this court has already, see, this is not an appeal of a denial of a motion to dismiss. This is the second motion to renew. This court already affirmed the lower court's holding that favoritism towards SACAR, outright favoritism, unfairness, doesn't satisfy that Schatz standard. And Justice Kapnick and Justice Friedman, you were on that panel.
Yeah.
And what's being told to you here is a rehash of those arguments.
There's something here which justifies a renewal.
Excuse me?
And whether there is something here
Correct.
to justify a renewal from that previous decision of this court.
That's correct. And I'd like, my adversary said over and over again that one of the emails that they adduced said that if you don't turn this over to us, you don't turn this product over to us, we're going to. I'd like you to look at that. It's at page 528 of the record. And what it says is, you know, we believe this product is infringing on our rights, and if the delineation is not resolved and this doesn't infringe on our rights, we're not going to renew. We have examples of emails coming from Gemini, which we cited in our brief at pages 31 and other places in our brief, where they're essentially making all kinds of arguments to my client about why what SACAR is doing is outrageous and is violating their rights and is trampling on their rights. And they're in the same tenor, they concern the same subject. And our client simply exercised the discretion that it had. Now, our client, I don't believe, by the way, that you know, the Schatz line of cases, and by the way, you know, we're talking about hundreds of cases. There are 3 cases cited in my adversary's brief. You'd figure if there was more authority that supported that position that they would be cited. The enrichment has to be improper in some respect. Here, what you've got,
Wasn't there some allegation that there was somebody that worked, there was some kind of connection between someone that worked for
Yes, and that
SACAR
was the subject of the previous renewal, in which this court said, even if we took their dubious assertions as true, that would not form a basis for renewal.
Is SACAR a passive shareholder in Infinity?
It is. It's a passive shareholder in Infinity, but it doesn't go the other way around. Infinity doesn't have any interest in SACAR.
Infinity isn't enriched just because
Just because SACAR is enriched. And
except insofar as they may be selling more product and they're earning more licensing fees.
That's exactly right. And so what you have here, and you have this evidence going both ways in the record, including evidence that they had at the time that they opposed our motion to dismiss when it was made. So none of this, really what this is about, is have they satisfied the standard on a motion to renew, the second motion to renew, post-appeal. And when you strip out everything in the briefs and everything that they've put forward in the record which does not include substantial submissions from my client that were part of the record before the lower court, which were linked in our papers, and which we mentioned in our briefs, there's nothing new. This has all been decided. It's been decided by the lower court. It's been decided by this court. And the question here is there an abuse of discretion here? We're not starting from a clean, brand new slate. Have they set forth enough to state a cause of action? This is renewal. This is a second renewal. If the court has no more questions, I'll rest on my brief.
Thank you. Counsel, you have 2 minutes.
Thank you, Your Honor. So the first thing that I would like to bring to the court's attention is that the first appeal was not decided on the substantive merits of the case. The court reviews its prior decision and will see that the court declined to reach the merits of the argument under appeal, finding that the issue had not been properly preserved. In the prior appeal, plaintiff had argued that the trial court was incorrect when it stated that in order to satisfy the Schatz standard, you have to show self-enrichment, because many of the cases following Schatz had found it was sufficient to show that an abuse of discretion, regardless of the motive, came under that standard. The appellate court did not decide that issue and found that it hadn't properly been preserved for appeal. So the notion that this is just a repeat of an issue already decided on appeal is absolutely not correct. I want to briefly answer a question that the court had addressed to me a moment ago about couldn't your client have better protected itself? That is true of any of the cases that follow the Schatz v. Shertuck precedent, and there are dozens of them. I only cited 3 because they're all exactly the same as each other, but there are dozens of cases that follow that precedent. And any of those plaintiffs, the court could have said to them, well, couldn't you have done a better job in protecting yourself? And the answer in all cases is maybe, but that doesn't mean that the law is not that if a party to a contract abuses its discretion in order to enrich itself, then they have breached the implied covenant of good faith and fair dealing. And here, what is new is that for the first time, because of discovery in Infinity's case against Gemini, there was evidence that they did that. We're not just talking about the fact that they agreed to take my client's best-selling speaker and turn it over. They also agreed, because of pressure from SACAR, SACAR sent them a letter saying, if you don't stop them from selling the speaker right away without a 120-day sell-off, which is clearly stated in the contract, we're going to withhold royalty payments from you. So in order to enrich itself and make sure that it got those royalties, it said, okay, we're going to stop you right away. That was a brand new, we had no idea about that because we had never seen that letter until we got it in discovery. So there is clear brand new evidence which provided the exact level of evidence that the trial court had stated we needed to provide. We provided it.
Okay, counsel, thank you very much. We will take another look at the papers. Thank you for the arguments. Have a nice afternoon. The next case for argument is Cruz versus Aging.
Good afternoon, Your Honors. Greg Friedman for the appellant. I'll start out with this. We know the plaintiff arguing equitable estoppel almost invariably has an uphill battle. So I think the question here is there enough to get us over that hill? I think when you look at the sequence of events here, starting with the accepted for MTA, you move on to counsel conducting the 50H, and then they answer for somebody who they claim they don't employ and have no obligation to answer for. I think even if you say that maybe plaintiff's counsel could have done a little more investigation here, did they feel the need to do so while they're basically being lulled into thinking that they're fine?
Well, I mean, there are cases that say that the appearance at a 50H hearing does not justify equitable estoppel. And in this particular case, the defendant in their answer, which I know came a little bit later, but this was during COVID, so the statutes were moved a little bit and were told. They told you in the answer that they didn't own the vehicle and that they, that plaintiff wasn't employed by that defendant. So, I mean, you really did have notice before the statute of limitations ran.
They did serve the answer within our time to, if plaintiff wanted to, move to file late notice of claim against the TBTA. Based on the case law, I don't think that the answer alone categorically precludes estoppel. It's fact sensitive, and I think of all the cases that we cite, that defendants cite, no two of them are exactly alike here. And it might sound a little backwards, but I think the most support for our argument comes from this court's decisions rejecting estoppel, because all of those seem to go into great detail about the things that the entity defendants did do. They basically all suggest that it was important that they give some indication as to who the real party in interest was. You have Dela Cruz, Nowinski, Luca. I don't need to repeat everything they said, but they all effectively recited how the correct party corresponded with the plaintiff, conducted the 50H, in other words, handled the claim. And in our case, it was the MTA and only the MTA that did that here. And for those reasons, I think the fact that they put in, I don't want to call them boilerplate denials in an answer, but that they denied owning the vehicle or employing a GEM aren't enough to outright eliminate an estoppel argument. I'm happy to answer any other questions, but it's a limited record, so I don't want to repeat what's in the brief.
Okay, well, why don't we hear from the respondent? You'll have a minute to
Thank you.
reply. Thank you. Good afternoon.
Good afternoon. May it please the court, Jonathan Goldsmith for the respondents. Your Honors, it's a well-settled area of law, and nothing was done in this case to mislead the plaintiff into believing that service of a notice of claim or a complaint on the MTA was service on the appropriate party in this case. The fact that the MTA stamped on the notice of claim accepted for MTA only suggests it would not be effective as to any other party. And there is no reason to believe, and I think if you follow plaintiff's argument on the notice of claim to the logical conclusion, they say, well, accepted for MTA only means they accepted responsibility, they accepted liability. No, that's not a reasonable interpretation. MTA only. MTA is the only entity on whom the notice of claim was served. Unfortunately, in this case, it wasn't the correct entity. The 50H was conducted, as Your Honor mentioned. That's not dispositive of anything. There was no misrepresentation made. And then when the answer was served, it was in numerous places. I mean, there were denials of the allegations as to the MTA, and there were affirmative defenses which are not required to be asserted, that were asserted. It's a bonus to inform the plaintiff, there's something you need to pay attention to here. The MTA is not the appropriate party. The answer says there is no claim against the MTA. And the notice of claim was not properly served on the individual that, that they sued. So there are, as I said, it's a well-traveled path, and there are numerous cases, and Counsel in their reply brief.
Actually, they never served a notice of claim on the individual, did they?
That's correct.
It was just on the MTA.
It was just on the MTA, and the affirmative defense says that. It says you did not properly serve a notice of claim against the individual.
And by the way, the one you served on us is wrong because we're not the correct party.
It says the notice of claim was not properly served on the individual, and separately, there's no basis for relief or for a claim against the MTA. So we cite to a number of cases that talk about, I'm not going to go through them, but it talks about not only, as counsel says in their reply brief, when the notice of claim is not served timely, they also talk about when they're served on the incorrect entity. Polsky, Kane, Reese, and Seeley, which we requested be added, are prime examples, and there are many more, as your honors may know. So if there are no questions, I'll rest on the brief. Thank you.
Okay, thank you. Counsel? You have a minute to respond.
Sure, and I'll try to make this very fast. Let me just start with Seeley, which I've seen the case. So I have no problem with him trying to put it in last minute. But Seeley is like some of these other cases where the claim there was that the Health and Hospitals Corporation did or didn't do something wrong, but they had no involvement in the case from the get-go. In our case, it's the MTA that have been handling it from the start, and we're claiming that they should be stopped. I think there's a big difference there. Quickly, with the accepted for MTA stamp, we disagree as to what that language meant, but this is summary judgment against us. You have to give the inferences in our favor. So when you look at that word accepted, what else is plaintiff supposed to think other than that, okay, we served the right entity here. I know there's case law that basically says MTA doesn't do public transportation, they don't control any facilities. Obviously, this case involves neither of those things, so I don't think you could say that counsel should have automatically assumed that a defendant other than the MTA should have been served here. And very last sentence, I'm done. Again, I just urge you to look at the cases that otherwise would be against us. I think all those facts are cited about the correct party doing the 50H and handling the claim have to have some import, otherwise this court wouldn't have discussed them as much as they did.
Okay, thank you both very much. Manganiello versus Vitanza. Good afternoon.
Good afternoon. May it please the court. Christopher Della Carpini for the appellant, Mr. Manganiello. So Justice Lattin denied Mr. Manganiello summary judgment on liability because supposedly there is a triable issue of fact as to who gave the command to coil the windlass when it crushed Mr. Manganiello's fingers. Well, it can only be one of three people, right? Because there's only three people on this boat in the middle of Long Island Sound. So either Mr. Manganiello gave the command to coil the windlass around his own fingers, or Mr. Weiss, who was operating the windlass, shouted the command to himself, or Mr. Vitanza, the ship's owner and captain, shouted to Mr. Weiss at the other end of the boat to coil the windlass without knowing where Mr. Manganiello's fingers were. So what does the record say? Well, Mr. Manganiello and Mr. Weiss, a non-party witness, both testified unambiguously it was Mr. Vitanza.
Weren't they friends? I mean, didn't Mr. Vitanza know Mr. Weiss through Mr. Manganiello?
Yes, they were all friends, three friends out for a day of fishing on the Sound. And two of those friends testified it was Mr. Vitanza who shouted the command to Mr. Weiss to coil the windlass.
And Mr. Vitanza did not remember exactly what happened.
Exactly, Your Honor. All he had to do to create a tribal issue of fact was come into that deposition and say under oath, I did not give that command. That's not what he said. What he said, page 237 of the record, question, and as you sit here now today, do you remember who gave the instruction to Dennis, Mr. Weiss, to activate the windlass at the time George's hand got stuck in it? Answer, no, I would not be able, I don't recall. I wouldn't be able to say that with any certainty. All the memories are just blended into a very cloudy thing. That doesn't raise an issue of fact, Your Honor. In fact, that's Mr. Vitanza admitting that he can't raise an issue of fact. That's why it was error to deny Mr. Manganiello summary judgment. He presented prima facie evidence of liability. Mr. Vitanza couldn't offer any evidence to raise a tribal issue of fact.
You do now agree that there is an issue of fact as to whether or not there had been a prior problem with the windlass, but that should not affect the determination you're requesting us to make at this time.
We agree to both those, Your Honor. We pleaded 2 theories of negligence. One of them, liability, is undisputed. There's no need to have a trial on the other one. I will say Mr. Vitanza also raises in an appeal that there is supposedly an issue of fact as to proximate cause, based on his expert's testimony. Justice Lattin didn't find any issue of fact as to proximate cause, and they don't say that Mr. Manganello was the sole proximate cause here, and that would be all that matters, because if he's comparatively negligent, he could still be entitled to summary judgment on liability. That would go to damages.
The comparative negligence, even if you prevail and get summary judgment, partial summary judgment, the comparative negligence still remains an issue for trial.
Comparative negligence would be an issue for a damages trial. It would not be an issue on liability. We could still have summary judgment on liability. That's the Rodriguez decision,
Right.
CPLR Article 14. But he wasn't even comparatively negligent. He clearly just provided the occasion for the injury by putting his hand on that windlass. He could have had his hand there all day and not gotten a scratch unless and until somebody coils the windlass. If there are no further questions, we'll rest on our briefs.
Okay, thank you. You'll have a minute for rebuttal if you want it. We'll hear from the respondent.
Good afternoon. May it please the court, Kyle Silverstein of Morrow, Lilling, Naparty, on behalf of respondent Mr. Vitanza. This court should affirm the motion court's denial of plaintiff's summary judgment motion because there are issues of fact that still exist. Namely, even when looking at the plaintiff's motion in a light most favorable to the non-moving party, respondent, there is an issue here. Plaintiff in his deposition says he heard the word go and then his hand was injured. Defendant says that they were all working together as a team, trying to get the anchor to move, trying to get the boat to move. Mr. Weiss says that he acknowledges that he was getting directions from both people and that even though they may not have been talking over one another, he did acknowledge that they were working as a team as well. Furthermore, defendant also said that plaintiff and him both used the word go in trying to get this boat to move. So looking at that, along with the fact that his I don't recall, looking at the whole thing, not just the statement I don't recall, that should be enough because the plaintiff did not eliminate all issues of fact because it's his burden to present that prima facie case. Furthermore, their defendant respondent did meet his burden regarding presenting an issue of fact because the expert letter attached by Mr. McDonough says that the plaintiff was the sole proximate cause of the injury.
How could he be the sole proximate cause? I mean, his hand was near there, but until Mr. Weiss in the back flipped the switch, he was okay. That was the problem, that he flipped the switch in the back. Somebody had to tell him to flip the switch.
That's very possible, Your Honor. However, on a at this stage, on summary judgment, all inferences have to be to the non-moving party. The expert just has to basically show that he analyzed the boat, he analyzed the anchor system, and he determined that it was working fine. Well,
this was 2 years later, though, wasn't it? Might have been working fine then.
As they conceded already that there was no prior notice, that would be an issue of fact as well, that whether or not the anchor was working fine or whether or not the captain, as we're calling him, or defendant, had noticed that the anchor system was not working fine. So beyond that, the defendant's letter by Mr. McDonough saying that he was the sole proximate cause, that he put his hand in an open and obvious hazard, would be enough.
Well, again, as we said, there might be some comparative negligence, but the Rodriguez case does not prevent us from granting summary judgment against the defendant and then ultimately finding that there was some comparative negligence on behalf of the
Right, Your Honor. However, this is not just saying that plaintiff was comparatively negligent. There's still the requirement that the moving party, or in this case, the plaintiff, has to prove that he was not the sole proximate cause at this point. This is not a case of comparative negligence. Mr. McDonough wasn't saying, well, it was defendant's fault.
I thought you only used sole proximate cause in labor law cases. I never heard it in this, but, okay.
This is not a case of comparative negligence. It's just a case where the court has to find an issue, and in this case, there were issues of fact. Therefore, this court should affirm the motion court. Thank you.
Okay, you have 1 minute to respond. Thank you.
Thank you, Your Honor. I appreciate counsel's concession. This is not a case of comparative negligence. We'll remember that. But I do want to get to his characterization.
There's no
of the
record here. There's no record here.
Thank you, Your Honor. I do want to get to what Mr. Manganello actually said about what happened. Yes, they were giving commands both throughout the course of this effort to get the anchor up through whatever difficulties they were having. But I'll direct you to page 75, 76 of the record, Mr. Manganello's deposition. He's asked what happened. He answers, what happened was Michael Vitanza came up, and my hand was there. We were on a break, and the next thing you know, Mike picked up the rope, and he said, go. I wasn't aware he was going to do that, and before you know, my fingers were in the winch. Dennis hit the switch. Mike told him to. I wasn't aware, and boom, it went in. I'd like to also direct you to Mr. Weiss's testimony, page 150 to 151 of the transcript of the record. Question, did Michael tell you to push up and down? Answer, when George got his finger stuck, yes. Any questions? Thank you very much.
Thank you both very much. Have a good afternoon. The next case for argument is Mosdiak versus State University of New York. Good afternoon.
Good afternoon, Your Honors, and may it please the court. My name is Alan Sash, and I represent the appellant Stefan Mosdiak. On September 21st, 2021, an employee at SUNY Maritime saw the N-word carved into an elevator door on campus and reported it. The very next day, on September 22nd, Maritime issued a university-wide email asking anyone with information to report it to them. Within 2 minutes of that email being sent out, a freshman by the name of Tate Niederreyer, who was on the football team, sent an email.
Well, it seems like all these guys were on the football team.
Yeah, yes, you're right, Your Honor. They all were on the football team.
So we kind of know what happened because we looked at the record. So the question is, this email that came in 2 minutes later was not made available to the petitioner until after the hearing. Is that correct?
That's exactly right.
And your client asked to have the hearing opened or have additional opportunity to submit this email as exculpatory evidence in his case, and that was denied by the university.
That's correct. He asked the provost to reopen it, send it back. He didn't have this email before. He has it now.
There was an appeal after this decision unfavorable to your client. Where does this email fit in with that appeal?
Sure. So the email was sent on September 22nd. The hearing was held, I believe it was November 12th or around early November. He was found responsible. 13 days after he was found responsible by the hearing panel, he received the email from the university police as part of a criminal proceeding. He had 1 day left before his appeal expired. He then went to the provost with the appeal and said, I just got this email. This is exculpatory. Please give me another hearing. And the provost said no. Number one, she said it was not compelling, which we can't explain why, and neither does she. And number two, she said it wasn't corroborating of anything, which he said, I didn't do it. And it's not only Tate Niederer, but his mother as well, who was with him at the time. So all we ask is to be given due process and a fair hearing and go back with this email to a hearing panel and bring these two in as witnesses so the panel could have both sides of the story and make a decision.
Am I correct that the criminal case was dismissed?
Correct, it was dismissed.
And he's been suspended?
He's been expelled.
Expelled.
And he wants to go into public service, and he can't go into public service with this.
Starting out with this kind of record.
Correct.
How would the how would the new hearing panel be made up? How would that be made up of whom?
So I believe SUNY Maritime has 14, like a rotating bench, if you will, of 14 judges, and it's made up of students, administrators, professors. So I think only 3 were used up this time around. So we could send it back and get a whole new fresh panel and give them a fresh trial.
So you're asking for us to remand it so you can have another hearing where this evidence would be available for the hearing panel to review?
Exactly right. Thank you, unless the court has any more
Any other questions? All right, well, let's hear from the respondent. We'll let you have
Thank you.
a minute or two to respond. Thank you.
Good afternoon. I'm David Lawrence III. I'm an Assistant Solicitor General appearing on behalf of Respondent, State University of New York. Crucially, the petitioner did not ask in his administrative appeal that the administrative hearing be reopened, that there be another hearing. Instead, it's at page 167 of the administrative record. The relief he requests is, I respectfully request the dismissal of the charges against me. He did not ask.
And based on that, that's, I mean, I saw that in your papers, and because he may have used the wrong word, you're not going to give him an opportunity. I mean, your provost wrote a short letter on December 3rd, which said he considered the request, and I must deny your appeal. I carefully reviewed all materials. She said, but found neither a procedural error nor the new evidence to be compelling or corroborated by other sources. Didn't say you asked for it wrong. It just said, you know, I just didn't find your evidence very compelling. Didn't give any reason why this wouldn't be compelling evidence.
In answer to Your Honor's question, the petitioner was represented by counsel. Counsel wrote an extensive 21-page, single-space administrative appeal letter. Counsel was very clear about the relief the counsel was asking for. Also, petitioner's Article 78 petition does not ask for a new hearing, and the brief does not ask for a new hearing. This is something that was raised for the first time at this oral argument.
I mean, don't you find the facts of this rather disturbing? There is this piece of evidence which really utterly refutes everything that's been said against the petitioner, and somehow this whole hearing procedure results in it being just totally disregarded.
Well, the administrative appeal procedure specifically allowed
You can't believe that this email that he's given late in the game is something that he had a role in making up. I mean, that email goes out 2 minutes after the letter is sent out asking for information.
Yes, Your Honor. Fortunately, the administrative appeal procedures allowed the petitioner to raise new evidence on his administrative appeal. On his administrative appeal, he did not ask for a new hearing. That left it to the provost to decide whether to credit that email over the abundant other evidence.
Does the administrative appeal permit for this sort of compelling new evidence to be considered on the appeal?
Certainly, that's one of the 3 grounds expressly stated in the appeal procedures that one can raise new evidence of which one was not aware at the time of the hearing on the administrative appeal.
Do you know why the university did not produce this email sooner? Or apparently they didn't produce it at all.
Yes, Your Honor, the record reflects that the judicial officer who was acting as sort of the liaison in this case was in communication with the university police several times. She did not receive it from the university police, so she was not aware of it to produce it to the petitioner. Plus, there's the separate legal issue of whether had an obligation under the university procedures to provide discovery, but even assuming that she had an obligation to produce it, if she had it, she didn't have it, and therefore was not able to produce it.
And here the provost seems to have made a credibility determination with regards to that email. Is that something that the provost is empowered to do, or is that something that should be before the board?
That's something that the provost can do because administrative agencies make credibility determinations based on papers all the time. I'm thinking in particular of Office of Children and Family Services, maltreatment proceedings. You have a caseworker's case notes against the petitioner's administrative hearing
But isn't that
testimony
more
denied.
that credibility determination, isn't that more properly before the board as opposed to a provost on an appeal?
It was before the board in the first instance, but when the petitioner...
Well, it wasn't before the board, right? The board didn't know about the email.
Yes, Your Honor, what I'm saying is that it was in the first instance for the board to make credibility determinations, but when petitioner brought forth this new evidence, did not ask for a new hearing before the board, it then became incumbent upon the provost to make that credibility determination on the appeal.
I mean, how can you make how could they make a credibility determination? None of the people testified, I don't think. So you get this document a copy of this email, which clearly contradicts the other testimony. I mean, shouldn't the court want to, or the provost want to find out what really happened?
It's well established that hearsay evidence is admissible on...
How's that hearsay? The person said, this is what I saw. I don't see how that's hearsay. That person, Mr. Niedermeyer, well, that the freshman who saw that said, this is what I saw. How's that hearsay?
It's well established that there's no right to cross-examination in administrative proceedings, that evidence can be considered that's basically based just on papers and not based on oral testimony.
There's no right to cross-examination in that?
Well, there's no right to...
That depends on excuse me, but that depends on whether there's a contract that you're operating off of or some code of ethics. It's not an established right as a matter of law.
Right. Let me clarify my answer. There's a right to cross-examine someone who actually testifies. There's no right to have somebody testify in order that they may be cross-examined.
Most of these proceedings do give the accused party the opportunity to call witnesses.
Yes, Your Honor, they do. And a party may call witnesses or a party may choose to rely on written evidence.
Any further questions?
We're supposed to be deciding if what happened here is arbitrary or capricious too, right? Don't we look at that standard?
I'm not sure I heard Your Honor's question.
I said one of the things that we're supposed to be considering here, our standard of review, is arbitrary and capricious. Is that correct?
Is
arbitrary and capricious.
I'm sorry. Essentially, arbitrary and capricious or substantial evidence, both very deferential standards of review.
Well, yes, but those are two different things.
Well, yes, arbitrary and capricious is where you have a administrative proceeding that's decided simply on papers. Substantial evidence where it's based also on testimony before a hearing board.
Thank you. Counsel, you have 1 minute to respond. Actually, we have 2 minutes to respond.
I just want to raise one point regarding the standard of review for the provost. When the appellant appealed to the provost, he could only do it on 3 grounds. 1, disproportionate sanction, 2, new evidence, or 3, procedural error. And our position has been that there was new evidence and procedural error.
What about, counsel said that you did not specifically ask to have a new hearing. What did you ask for?
We asked for it to be reversed based upon the new evidence and the procedural errors. So, and I think in that 20-something pages that was sent to the provost, I mean, it's all in there and we cite to it in our brief. So unless the panel here has any more questions, I'm happy to rest on our brief.
So, just so that I'm clear, you're saying that in the 20-some-odd page of that letter appeal, the request to have a rehearing is somehow shoehorned in there somewhere?
I think it's at the very end when he requests that it be reversed. I think that's the language that he uses, that the decision of the hearing board be reversed based upon the procedural errors and the new evidence.
Okay, thank you very much.
Thank you.
Next case for argument is Hartley versus Burnside Housing.
Good afternoon, Your Honors. May it please the Court. Matthew Corcoran for the appellant Burnside Housing. This is an appeal from our motion before Justice Taylor in Bronx County, who found that we didn't adequately show that either the plaintiff didn't fall in a wet condition or that there was a lack of notice on behalf of our client. As to the first point, I think Hartley's testimony is quite clear. She testifies she walks into her hallway, she doesn't see any water on the ground, she falls, none of her body is wet, she doesn't feel moisture on her clothing or her body. She turns around and sees some water on the landing of the steps behind her. This case is fairly analogous to another First Department case, Ragu versus New York City Housing Authority, where the plaintiff sued her landlord, alleging she fell in some white powder. However, she only saw the powder in the hallway after her fall. She testified she didn't see any where she stepped.
Well, I mean, looking at the videotape, she came out of her door, I think picked up maybe a bag of garbage or something that she was going to carry down with her, took one step and fell.
Correct.
So she didn't have too much time to, see exactly what was going on there. But what about her claim that there was a recurrent condition of
Dogs
dog
urinating.
urine, wet situation that was not being addressed by your client?
So I would argue that's not actually evidence of a recurring condition. That's what the court considers a general knowledge that a condition might be in a building, which the court has decided is two different standards. This case is also analogous to another case of the First Department, Gloria versus MGM. There, the plaintiff sued a nightclub owner because she slipped on a spilled drink. She claims that the nightclub knew that there were spilled drinks on the floor, so they had a recurring condition. The court said, no, this is a general awareness that a condition can occur. It's not a situation the landlord or the owner can stop or guard against because it's people spilling drinks. It's dogs urinating in hallways.
It's also a situation where shortly before, your employee had actually tended to the steps.
He did. And at that time, he said that there was no water or wet condition or liquid or anything on the floor when he cleaned. And that's another issue they raised in their respondent's brief. They're claiming that we need logs or we need paper records of the fact to prove that Inicio Gomez cleaned the area.
It's not when you provide live testimony of actually having swept or mopped.
I'm sorry, Your Honor?
It's not where you provided live testimony of actually having swept or mopped in and about the time of the accident.
He provided testimony that he cleaned the area only a couple.
You don't need a log when you have the witness coming in and said, well, I swept the area.
Well, I'm going to go back to that case of Ragu, which is also analogous on this point.
So it wasn't a hostile question.
Oh, no, I'm sorry. I'm sorry, Your Honor. So the masks make it very difficult to tell. I'm so sorry. But on that point anyway, in Ragu, testimony of an established cleaning schedule and a specific recollection that that cleaning schedule was followed on the day is sufficient. A log is not necessary. I'm sorry again. Going back to the recurring condition, the only condition that Hartley raised in testimony that might have been recurring is that dog urine, which again, not a condition that a landlord can guard against. So as the court in Gloria said, the landlord needs notice of each specific instance when it occurs. It could occur anywhere in the building. It could occur from multiple dogs. It's not something they can stop. There were other recurring conditions brought up in the affidavit of her husband, Darrell Kelly, specific to the window being left open in the landing, garbage being dragged around, and actually people urinating in the hallways. With respect to those latter two, same issue with the dogs urinating, not something that the landlord can cure against. With respect to the window, I'd argue that not only does plaintiff's own testimony establish the window was never open, and also that it wasn't raining on that date, so that really does seem like a red herring, but with respect to the window argument, the people urinating, garbage being dragged, those were all points brought up by an affidavit in opposition to summary judgment, which were inconsistent with Hartley's own testimony, and for that reason, that's why we argued those points should not be considered by the court. Unless there's any other questions, I'll step down for now.
Okay, thank you.
Thank you.
Good afternoon, Arnold D. Joseph for the plaintiff respondent in this case. Justice Friedman, you brought up the fact that Mr. Gomez had claimed he swept. The trial court was very specific if you read its decision, and they raised the specter of Mr. Gomez's testimony in the case being inconsistent in places, especially where he says, one, he's been working there since 2008, and he's seen tenants take garbage, take it and spill it and be in liquid, and he would have to clean it up. And the same testimony said from 2008 till the time of the accident, that never happened. Also, the defendant here, that's great that they have no written records. There's a video in this case. Isn't it amazing that the video starts at 9:57 and then goes for some reason till 5 o'clock in the afternoon? But it doesn't show, or they didn't supply, the time when Mr. Gomez said he would be present. And I always laugh at these videos that defendants supply in slip and fall cases where they know notice is an issue and they start the tape.
But Mr. Gomez did testify that on the day of the accident, he swept the stairs between 7 and 9, and was done early with his tasks, and she claims that she fell
at 10.
Yeah,
3 hours,
around 10
about 3 hours later. Yes.
That's about, well, unless she was the last place to be swept, then it was 1 hour later. But anyway, I mean, Mr. Gomez is not supposed to spend his entire day sweeping stairs,
And
right?
nobody's saying that he is. And that's where you asked about the recurring condition. You know, this affidavit of the husband, if you really read what happened in this case, the affidavit is admissible here. And the reason it is because they didn't move properly to get rid of it. Whatever the procedure is, there's a discovery court. The discovery court said, your order to show cause to strike the affidavit's denied, remake it in front of the judge that's here in the case. They never remade it. They brought it up in their reply. They never mentioned it in their appeal. The trial court dismissed the case based that the defendant didn't make out a prima facie case.
Wait.
Go ahead, I'm sorry.
No, you can talk.
I don't think this is
I'm not
gonna
sure
be-
counsel heard you trying to speak.
No, Judge, I...
Go ahead, Judge
I
Friedman.
thought maybe you were still answering Judge Kapnick.
Go ahead, Judge, I'm sorry.
But going back to the video, so when she walks out of her door, she goes to the side and she puts something down or she picks something up. Is there
Yes.
any evidence as to what she's doing when she makes that move towards the wall opposite her door?
She says she was carrying a bag of garbage in her testimony, Judge. That's what she was picking. That's what she had to be
Because you
carrying.
can't see what's in her hand on the
Correct.
video.
And that's the problem, too. It's so far away, you really...
See the fall, but you don't see.
Right. And that's my point about where's the video that, they have of their porter cleaning the steps. It's 3 hours before. Why to give us 5 hours after the accident? It's not relevant. I said, but you don't have the material beforehand. And so I think what the judge is saying here is what the trial court was saying here, based on Mr. Gomez's testimony, there's no tape. I'm going to err on the side of caution and say, hey, summary judgment, it's not the trial, summary judgment denied, and that's all that's here, and I think the decision should be affirmed. And again, just to go back to that little tricky thing about this affidavit, parties chart their own course in the litigation. So if you're told by a court you got to renew your motion in front of the trial court, and you don't do it, then don't expect to get the relief that you were seeking. You charted your course, and that's what happened. Thank you.
Thank you.
Your Honors, with respect to that affidavit, first of all, it's honestly irrelevant what we did or did not do or may not do in the lower court action. This appeal is limited to this record, which the affidavit was submitted on opposition. We presented our argument on reply that it should not be considered due to inconsistencies, and that's what's before the court. If I'm recalling correctly, Doris Gonzalez's order, who I believe issued the first order, said that she would refer to the trial court judge for the question as to the admissibility, not that we had to remake it. We may, but again, that's not in this record. It's not relevant to this appeal. Regardless, with respect to the demand for the video, respectfully, there's no demand for the time before this. There's no argument that my client didn't clean, that Dionisio Gomez didn't clean at that point in time. It really seems like it's just grasping at
And
straws.
the appearance that appears in the video, it looks like a well-kept floor.
Thank you, I agree, Your Honor. But regardless, there's just, with all due respect, sometimes our clients are not the most sophisticated. They don't know what portions of a video they need to give to somebody. They don't know what they need to have available. They give what they have. By the time, unfortunately, we get to them,
You're saying there was
gone.
no request for the period before this video?
There's no request that would have been made during the time the video would have still existed. That's what I'm saying, Your Honor. And if there's no other questions from the court, I'll rest on the papers.
Okay. Thank you, counselors. Thank you both. People versus Hayworth.
Good afternoon, Your Honors. Abigail Everett for Appellate Keith Hayworth. Turning to the Orama point. Court has an obligation to give counsel meaningful notice regarding jury notes. At a minimum, that requires that the record show either, and this is the simplest thing, showing the note to counsel, or
reading it verbatim.
Reading it, well, verbatim, or as this court held in Carter, nothing more than a minor inconsistency that doesn't alter the meaning of the jury's note.
So was part of the problem here that it seems that somehow the judge didn't mention that there was a question relating to count 9 of the...
Exactly, and I don't think that really, when the jury asks for a reading of the only count they convict of, and that is not included in the on-the-record reading of the note, I don't think anybody would find that not to be omitting a key term. I think that the more, probably what we need to look at is whether or not the jury coming back with a verdict alters this analysis. And although the respondent does take that position, if you look at the Court of Appeals decision in Parker, you can see that that also, the Court of Appeals has addressed and rejected. This case is remarkably similar to Parker. Parker, to remind Your Honors, you had 2 notes that were not answered. The defense lawyer knew there were notes that hadn't been answered, and the judge said, we're going to deal with those after lunch. In the interim, the jury returned a jury verdict note, just as in this case.
But was it clear in Parker that counsel knew about those 2 notes? Isn't there some dispute as to that?
I don't think there's any dispute. I think the judge says on the record, we're going to deal with those notes after lunch. There was no reading in any way of those notes, but there's clearly, and particularly if you look at Judge DeFiore's quite long dissent.
Right. So, but this case isn't precisely Parker, because over here, counsel does know the note is read, of course, with a mistake, and certainly missing count 9 is not a trifling matter. But then counsel goes on to say, obviously, if they don't have any further questions, then they don't have any further questions. And the court says, and I will take a verdict, and defense counsel states, okay.
Right, but Your Honor, if you have a mode of proceedings error, which we submit you do, the defense lawyer doesn't have to object. What the Court of Appeals does say in Parker is that it's not meaningful notice to defense counsel to know of the existence of the note, and the Court of Appeals uses the language, you have to have an indication that the entire contents was shared with counsel. So here, as in Parker, you do not have an indication on this record that the entire contents of that note that we're discussing were ever revealed to counsel. It's not a meaningful notice that defense counsel was aware that there's a note out there that hasn't been answered and that now the jurors are ready to declare
They needed
verdict.
to know exactly what that note said is what
Right, whether or not, and because if you look at the cases that discuss the Orama error, one reason it's a mode of proceeding errors under these circumstances is the court recognizes that counsel will make decisions about how to deal with this appropriately based on knowing the the full note, so that although it's true that in this case the lawyer did say, well, if they don't have any questions and they're ready to announce a verdict or something to that effect, but he hadn't been given, as the Court of Appeals said, the entire contents of the first note, so you really can't assess the significance of that. I see the white light is on. I do want to very briefly touch on the excessive sentence. This is a case where the probation department, after they prepared the report, acknowledged that we needed a psychiatric evaluation. That's unusual for the probation to ask for a psychiatric evaluation after they do the report. And this evaluation clearly indicates that Mr. Hayworth had paranoia arising out of the circumstances of his mother's death. There's documentation that his treatment of his small business he let deteriorate because he had this perseverative obsession with his mother's death and his father's dealing of the estate. This is a person.
Didn't it? I mean, honestly, and the judge mentioned this when she was doing her sentencing. I mean, your client attended very good schools. He got a lot of money from his mother's estate. The father got very little money from the estate. You know, it was not, as the judge said, the general type of situation that she normally sees.
Right, but this is an unusual case, Your Honor.
And this father, you know, his life is destroyed. He could not live alone anymore. He was terribly injured.
The court should remember that the jury acquitted of 8 of the 9 counts, acquitted of attempted murder, acquitted of first-degree assault.
Yeah, I'm aware.
So they had some questions about the facts of the case. He was convicted of a felony, which was physical injury, just physical injury when the victim's over 65. This is a person who does have an enormous ability to reintegrate. He does have that excellent college degree. He's got no prior record. He's got a wife and a child. So that I would ask the court to consider using its discretion to remand to reduce to a level that would make him eligible to come out now and be supervised rather than continue incarceration. Thank you.
Thank you.
Good afternoon, and may it please the court, Catherine Murata for the people. As an initial matter.
Turn to Parker. So in Parker, the court says, there is no record, however, indicating that counsel was informed of the precise contents of the other 2 notes. The court thereby failed to fulfill its obligation under ARAMA. There's no question that counsel wasn't informed of the precise details of the note. He wasn't even told about the count 9 question. So how do you get past Parker?
I think the facts of the instant case are readily distinguishable from Parker. In Parker, the jury sent out 3 notes within the span of an hour. This was all before lunch. The judge only read the first note to counsel before taking lunch and said he would read the remaining 2 notes after lunch. When he came back from lunch, the jury had a verdict and never read the remaining 2 notes at all into the record or provided counsel with meaningful notice of those.
So you have a situation here where the court read the note, but the court read the note inaccurately. How is that going to satisfy Parker?
Justice Pickles provided meaningful notice of the jury's first note because she read the note into the record in the presence of counsel. She informed counsel.
She left out about count 9. Are we all in agreement about that?
Yes. Justice Pickles did omit count 9, but in response to counsel's argument, she did read counts 4 and count 7. I think it's important to note that count 4 is burglary in the first degree and count 7 is assault in the first.
Count 9 is the count upon which the defendant is convicted.
I recognize that, Judge. But count 4 and count 7 are Class B felonies, much more serious counts than assault in the second degree, and carry a much higher sentencing exposure than assault in the second degree. So I think surely if Justice Pickles had said count 9, the defense counsel's input would have been the same. He had no issue.
She didn't say it.
I mean, the cases as I read them from the Court of Appeals and from our court are very clear that if there's an ARAMA violation, if you don't read exactly what's in there or, you know, without leaving out a count or something, which is, I think it's fairly important, then, you know, you've got to go back and do it again. I mean, there's not a lot of leeway. The Orama cases are pretty rigid in their findings.
I think this is a special case, Your Honor, because in this case, this was cured by Justice Pickles telling counsel that there was two conflicting notes, one with about the counts and one about the jury.
No, I understand, but she didn't mention everything that was in the note. I don't know how we get around that.
And she didn't read it into the record fully either.
Say it again, I'm sorry.
She did not read it into the record fully either.
She did omit count 9. However, I believe it's my position that it's still an almost verbatim reading. It doesn't need to be the exact word. It can be paraphrasing. It didn't. It's not.
Again, she left out the count upon which the defendant ends up getting convicted. And in Parker, counsel knows about the other two notes too. Is that correct?
In Parker, counsel is aware of the other two notes. The judge never.
And that doesn't become a basis for the Court of Appeals majority to say, well, that means that's enough and you can take the verdict. I mean, so the fact that here counsel is aware of the note, but he's not aware of all of the note, so the fact that he then agrees to the verdict doesn't really seem to be a distinction to what you have in Parker.
I think in Parker, the judge didn't read any of the two notes. Here, Justice Pickles read an almost verbatim reading. She did omit count 9, but as I said, she did mention counts 4 and 7, which were more serious counts. Defense counsel took no issue with those. He agreed to all the court's proposed courts.
You know, the Court of Appeals uses this phrase, precise contents, which doesn't leave us a whole lot of wiggle room.
Your Honor, I think in previous cases, like in People versus Jackson, the court's able to paraphrase and not use precise contents. When the court provides access to the jury note and allows for input, which happened here, defense counsel said, obviously, if they don't have any further questions, they don't have any further questions, and we can take the verdict.
Well, in 2016, I personally wrote a decision on Orama, the People versus Robinson, and Justice Friedman was on that bench with me also. And we said the requirement to give meaningful notice cannot be satisfied, quote, when counsel is not afforded a verbatim account of a juror's communication. The trial court failed to give meaningful notice of a jury note when it paraphrased the note for counsel, each time omitting a certain reference to the note's inclusion of one word. I mean, here it was the court omitted the inclusion of the one count on which the defendant ended up getting convicted. I don't see a way around this.
Your Honor, I believe that counsel had sufficient notice here. If he wanted to object, he could have objected. It's further cured by Justice Pickles brought the jurors out seeking clarification and specifically asked each of the 12 jurors, do you need to be recharged on any of the counts? They all said no, and the court took the verdict. So I can address the excessive sentence claim if you wish, otherwise.
I don't think that's necessary.
Okay.
Thank you.
We ask you affirm. Thank you.
Ms. Everett, you have 2 minutes.
Just to reiterate, my adversary talked about the note being almost verbatim. I really don't see how you could characterize this as even almost verbatim. In addition to the count 9 not being mentioned, you've got that whole thing that I didn't get into before with the carrots, and you can't really, it's hard to understand what the jurors are asking for. So, you know, there might have been some confusion. It's very difficult to kind of, after the fact, say, well, what might defense counsel's strategy have been had he gotten notice of the precise contents. So I don't think the court should accept the invitation to speculate that since they didn't ask for, he didn't care that they weren't reread on the upper counts, that he didn't ask for that. And unless there are any further questions.
I think we got
Thank you very
your
much.
points. Thank you both very much. The next case for argument is Mauve versus Griffin.
Good afternoon. If it please the court, my name is Jason Michel from DCL firm representing appellant David Griffin. This appeal is based on Justice Edmead's order granting respondents petition to confirm an arbitration award and denying my client's cross petition to vacate that award and dismiss the case. At issue here is whether or not the arbitrator's refusal to sanction the respondent for committing perjury and a willful
Didn't the arbitrator make a finding that there was no perjury?
The arbitrator made a finding that there was no competent evidence, but I believe the court should focus on what Justice Edmead said in her order, which stated that on its face.
I thought the arbitrator made a conclusion that the petitioner did not give perjurious testimony or false responses to discovery demands.
I'm sorry, can you repeat that?
I don't even have my mask on, but I'll repeat it.
Okay.
Arbitrator made a conclusion that the petitioner did not give perjurious testimony or false responses to discovery demands.
Well, even if the arbitrator thought that, Justice Edmead, after reviewing the record and our papers, she stated that on its face, respondents' willful failure to disclose, in particular, a stock purchase agreement that showed that respondent, in fact, had business dealings with my client's company after he had responded in an interrogatory and in testimony and in an affirmation in support of their petition that that he had no business dealings with my client's company. The willful lack of disclosure of this stock purchase agreement on its face supports my client's motion for sanctions. However,
but we're looking at the arbitrator's conclusions.
right, and that's why we filed a cross petition to vacate, because we believe that the arbitrator's conclusions were false. The arbitrator states there was no competent evidence. The evidence is, the record is replete with not only willful failures to disclose, but perjury. And Justice Edmead found that, in fact, yes, there was. And in fact, it would support the motion for sanctions. And the only reason why Justice Edmead did not rule in our favor is because she believed that the stock purchase agreement, because it was supported by $1 of consideration, meant that it didn't matter. To me, that's a preposterous decision. It's well settled that most agreements, are allowed to be supported by $1 in consideration. It happens all the time. The Mergler decision, this court's decision, the Court of Appeals have said that. So where does it end? You're saying that it's okay to not willfully fail, it's okay to willfully fail to disclose if an agreement is just supported by $1 consideration? It makes no sense. Where does it end? So if in fact, Justice Edmead felt that that agreement actually was supported by consideration, then the motion would have been granted. I'd see the lights off, so I don't know if you want me to continue.
Is there anything else you want to speak
Yeah, I
on?
would just focus on that and the fact, again, I think if you whittle it down to that her decision and the stock purchase agreement. Yes, 25,000 shares of a company were transferred for, in effect, $1. Doesn't matter why, that under the law, that was valid. And the fact that the respondent stated that he had no business dealings with that company and he wasn't a shareholder in that company, how can you possibly sell shares in a company that you weren't a shareholder of? Thank you, Your Honors.
Thank you. Good afternoon.
Good afternoon. May it please the court. My name is Moshe Mirsky. I represent petitioner respondent Chengong Jason Ma. The instance appeal is really a deflection of attempt to relitigate the arbitration, where the appellant respondent offered insufficient proof that that Griffin did not repay a personal loan of $300,000 based on an unsuccessful business relationship. focusing in, there was insufficient documentation, and Griffin's testimony was basically not credible. And the law does not support it overturning the arbitrator's decision in this matter, who heard the entirety of the evidence. As the court obviously knows, the standards to overturn an arbitration, it's manifest disregard of the law. The arbitrator was aware of this motion before the arbitration started, as during scheduling, it was raised by Mr. Michel. The arbitrator said, hold the actual motion for the end. So throughout the entire arbitration, the arbitrator was aware of the allegations, and still he found that it lacked any competent evidence. On top of that, this, what Mr. Michel is seeking is a drastic remedy, and it's also up to the discretion of the trier of fact, in this case, the arbitrators. Additionally, the allegations in the motions are not true. The other, as set forth, the other evidence or lack of evidence there was that Mr. Ma was never listed as a shareholder in any of the tax filings, never held any position, no operating or shareholder agreement. The $300,000 loan was used to pay Griffin's personal debt of the company called Mayfair that he had owned. And it's based, and basically this motion is based on Griffin's self-serving statements and emails. And even if true, the case is cited by Mr. Griffin, and those are all violations of court orders. All information documentation was to be in the possession of one party, whether or not there was prejudice, and therefore none of these existed. There were no orders, there were no violation of court orders, and even if what he says is true, it does not raise to the level of the drastic remedy of seeking sanctions of this type. The court has any questions?
Anyone have any questions? No?
All right, thank you very much.
Well, thank you very much.
Rest on my papers.
Just very quickly in rebuttal, I just want to point out that it is not necessary for there to be a court order violation in order to be successful in a 3126 motion for sanctions. It's all about having a good faith obligation to disclose. And again, one wonders why the respondent did not disclose the stock purchase agreement, why the respondent would state that he was not president of the company when in fact he signed a license agreement on behalf of the company and wrote that he was the president. We have argued that this is because he was trying to avoid the fact that he fraudulently induced my client into entering that loan because my client went to him and only accepted to take that loan because he believed that respondent was going to be an investor in the company and contribute to expenses and be an officer, and he did none of those things, or at least he claims that he did none of those things. And my client could have easily gone to a bank, but the point being is that the respondent should not be rewarded for what is an obvious willful failure to disclose. And again, I will just once again state that Justice Edmeade stated that on its face, the stock purchase agreement supports our motion for sanctions. And the reason why she ended up confirming the award was because that agreement was for $1 consideration. And under New York law, and probably under the nationwide law, people are allowed to make agreements for $1 consideration. And if you're claiming you're not a stockholder, then how can you sell 25,000 shares in a company that you're claiming you didn't own shares in? Thank you, Your Honors.
Thank you. Thank you both, counsel. Sloan versus Lawrence Nursing Care.
Just going to take a quick sip of water.
Go right ahead. Good afternoon.
Good afternoon. May it please the court, my name is Anna Bonventry, and I'm from Keller, O'Reilly & Watson. We represent the defendant appellant in this action, Dr. David Jacobson. This defendant appellant is asking this court to reverse the lower court's decision and grant the defendant appellant's motion for summary judgment, as there are no triable issues of fact presented by the plaintiff. In support of plaintiff's opposition to defendant's summary judgment motion, plaintiff's medical expert has relied on facts that are not in evidence. Plaintiff's expert has incorrectly considered the August 1st, 2014 incident as a fall. A fall involves a person's body hitting the ground. The record on appeal is replete with evidence that the plaintiff did not fall to the ground, including testimony by the plaintiff. Please refer to the record at 267, 271, and 282. Testimony from Robin Weiner, located at 661.
Not every fall involves hitting the floor or the ground.
Perhaps you're correct, Your Honor, but I do believe that in this case that a fall was distinguishable by each of the three incidents that plaintiff claims were falls. The incident on February 24th, 2014, the plaintiff fell in the shower when she hit the ground when she was showering and with soapy, slippery water on the floor. The incident on August 1st, 2014 involved the plaintiff entering a van when she was using her one right foot to step up onto a step.
How is Dr. Jacobson related to that?
The August 1st, 2014 incident? Well, Dr. Jacobson was related to that incident because he did recommend that she was at that time with a quad, she was able to use a quad cane with direct supervision. So as she was entering the bus to go on a trip, she was assisted by the van operator when she was going up the stairs. So at that time, those orders were being followed by LNCC, the nursing home. Whereas the incident on August 9th, 2014, she actually fell to the ground when she was unaccompanied by anyone going to her room.
That was what happened. It was inconsistent with the plan that Jacobson had propounded, which was that her mobility should be increased, but with close supervision.
I'm sorry, could you repeat that?
So the incident that happens on August 9th, she's supposed to be, according to Jacobson, he says that she's supposed to be closely supervised.
Right.
Right?
Correct.
On August 9th, when she's moving from one room to another room, she's not being closely supervised. Does Dr. Jacobson have anything to do with that failure?
No, I don't believe so. I think that failure was on behalf of the nursing home. The nursing home was responsible for following the orders of Dr. Jacobson, and the nursing home at that instant told her she could go to the room unaccompanied by any aides, and she did in fact go to the room unaccompanied and when she fell. So it is our position that the proximate cause of her fall was not any sort of fault on Dr. Jacobson in failing to issue another fall assessment, but rather LNCC's inability to follow Dr. Jacobson's orders by...
And Dr. Moynihan says that increasing her mobility was a desirable goal, and that's not contradicted, is it? Does Dr. Schwartz controvert that?
No, he doesn't controvert that. Mobility was important, and the plaintiff herself...
It's sort of a self-evident proposition.
Right, right. But the plaintiff herself also believed that she was capable of greater mobility at that time. She wanted to be transferred into a cane. She wanted more independence. And she, in fact, felt when she received the cane in August that she was able to ambulate with the quad cane at that time. So she herself believed that she was ready to ambulate with a quad cane, which is why Dr. Jacobson and physical therapy probably believed that she was mobile and of a par standard to be able to use a cane at that time and no longer needed the wheelchair. Okay.
Well, did they examine her or they just took her word for it?
No, he would examine her, as would physical therapy, observe her moving about the room. She also only used stairs during physical therapy, so she was being examined, And based on her ability, her improvement in physical therapy, which is shown by the records that she was improving mobility, Dr. Jacobson's orders all the way from May show that she showed better ambulation, that she was moving better, and that they thought it was best that to increase her mobility and her chances of being able to leave the nursing home was to have her walk with a quad cane, however, with direct supervision with any type of transfers, which would include walking to her room when she wanted to go to sleep on that August 9th, 2014 incident. And also, I just want to point out that the defendant's appellant Justice Capella correctly found that the defendant's appellant made out a prima facie case for summary judgment on behalf of the defendants. However, the plaintiff now, for the first time in their respondent's brief, argue that the defendant appellant's motion for summary judgment supporting documents failed to make out a prima facie case. Rather, the plaintiff respondent's reply to defendant's affirmation in support of summary judgment requested the motions be denied on grounds of competing expert opinions and triable issues of fact. This issue was first raised on appeal. I see my light is out, if you don't mind. I see that this issue was made first on appeal, and it was not raised in the papers below.
Okay, you'll have a couple minutes to respond. Let's hear from the plaintiff respondent.
Good afternoon, Your Honors. May it please the Court, I'm Leslie Kalmacher. The application below, as well as the appeal, is based really on a false premise, that being that this wasn't a fall. On August 1st, 2014, the day of the occurrence, which serves in part as the notice with regard to the defendant's liability, a note was put in the Lawrence medical record, and that note referred to the event very specifically, described it very specifically, and called it a fall. It was always referred to as a fall. That same note, which is in the record, also indicates that on that day, August 1st.
On August 9, 2014, while the plaintiff...
On August 9th.
On August 9, 2014, while the plaintiff is going from the dining room to her room, who's responsible to see that she is accompanied?
Your Honor, that the responsibility that day was on Lawrence, the staff of the co-defendant. However, there can be more than one cause of an accident, and that's our premise here. Yes, we say Lawrence is responsible. Clearly, they did not have her accompanied, but as the expert...
Dr. Jacobson had called for close supervision, had he not?
Absolutely, and
Who's supposed to carry that out?
That they required an aide should have taken her from the dining room, standing next to her, walking with her until she was returned to her room. And we agree that Lawrence has liability for that. That I don't believe is disputed in any way with regard to the facts that occurred. However, there's another part of this. She had had prior falls. There was the shower fall in February. And then on August 1st, she had this fall that we've been talking about when she got on the van. It's mischaracterized totally by the defendant, who would have you believe that she fell because she misstepped. That wasn't the description in the medical record on August 1st. On August 1st, it wasn't the description by the plaintiff herself. Additionally, on August 1st, as the records show, the defendant was advised that she had fallen. That was the word that was used. That's always been the word that was used. Parenthetically, I'll also mention that when the plaintiff was deposed and she was asked what happened, the question was, well, what caused you to fall? And there are at least 3 questions by defense counsel using the word fall. So the entire premise of their underlying application and the appeal here is absolutely false. This was a fall. But let me go back to the proximate cause question. Had Dr. Jacobson, who had been told on August 1st of 2014 of the fall, getting onto the van, which was caused because of lack of balance and or weakness in her leg, had he responded appropriately, he would have reassessed her and reevaluated her. And in doing so, one of the things that he would have considered was greater supervision or a change from the nature in which she was permitted to ambulate, less ambulation, or ambulation instead of with a quad cane with a walker, which would have prevented this accident. There are a number of ways this accident could have been prevented had the doctor heeded the earlier fall in February and heeded the fall with regard to...
Counsel, your expert doesn't say that had the doctor reevaluated that a modification would have been made. What your expert said is that he would have determined if a modification was necessary, if any modification was required.
Well, Your Honor, that's because in all reasonableness, the reevaluation should have and would have disclosed what was necessary, and more likely than not, there would have been a modification. That's how I read.
Your expert doesn't say that, however, right? I mean, it's totally possible that the doctor could have reevaluated her and concluded nothing else is needed.
Your Honor, that is not the way in which I read the expert's affidavit, because Dr. Jacobson could not ignore, had he done a reevaluation, could not have ignored the cause of the fall on August 1st. And that is that she had right-sided weakness, that despite her own evaluation or Ms. Sloan's own desire to do better, she wasn't doing better. She had weakness, loss of balance. She wasn't properly ambulating. More steps had to be taken in order to ensure that she would be able to properly heal and not have other falls, which is unfortunately and really catastrophically for her what occurred here. Just if I may make one very, very brief point, and that is that we disagree with regard to the position of the defendant. This court can find, as a matter of law, that the defendants failed to make out their prima facie case. The Court of Appeals has addressed that. We've discussed it in our brief. We're not asking the court to determine any other factual matter, just to make a determination as a matter of law that the prima facie case was not established in the initial summary judgment motion on behalf of the defendant. And my time is up unless there's questions, Your Honors.
Thank you.
Thank you very much.
Okay, I do want to address that the nursing home itself, I believe, differentiated those three incidents, the February 24th, 2014 slip and fall in the shower, the August 1st, 2014 incident with the van, and the August 9th, 2014 incident where she did fall in her room. I believe that's evident by the records, as it shows that a fall assessment was in fact performed after she fell on August 9th, 2014, and that's on page, I believe, 972 of the record. And that assessment has an important area where it says how many falls did the patient have. And under there it says indicate by a 2, that's one or two falls. 3 or more falls is indicated by a 5. The nursing home included the number 2, which makes me believe that the nursing home considered that the fall in the shower to be 1 fall and the second fall to be August 9th, 2014. So while the use of the word fall may have been in the records of LNCC, they also clearly distinguished on several pages that she did not fall to the ground, which I believe was the distinguishing factor between LNCC, the fall on August 1st, 2014, the incident on August 1st, 2014, and the falls on February 24th, 2014.
What is clear here, no matter how you view the events on August 1st or in February, is that as of August 9th, Dr. Jacobson's instructions insisted on close contact supervision with the plaintiff, correct?
Correct.
And if she had been accompanied even with her quad cane, although she got to put the orthotic on, but with or without it, it's more likely than not there would not have been an accident.
Correct. That is our position. And I also agree with you that the plaintiff's expert did not say specifically that Dr. Jacobson, if he would have conducted some sort of further assessment, would have definitively required one-on-one, 2-on-2 supervision or a walker. Rather, it is very possible, like you said, given her improvement based on the records and just the plaintiff's own account that she was improving, that he might have done nothing and continued his current orders for a quad cane and direct supervision.
Okay, thank you. Thank you both.
very much.
And our last case for argument today, As soon as, give council a minute to step out, is 419 BR Partners versus Sabar. Good afternoon.
Good afternoon, Your Honors, court staff, counsel. It's good to be back. May it please the court, my name is Daniel Schneider from the firm of Farber Schneider Ferrari, and I represent Eli Zabar and the other appellant respondents. This is a limited appeal based on RPAPL 881 and the application of legal fees and professional fees.
So it seems to me, at least, in reading the cases, Panasia and the case that was cited by Judge Saunders, the Supreme Court Kings County case, and several others, that everybody kind of agrees that if the petitioner had been able to, had won on their petition, that you might very well be able to get fees. But what happened is you won in preventing, in getting the petition dismissed, at least for now, and under no court rule or no statute or no agreement are you allowed to get legal fees. It might seem counterintuitive, but how do we get around that?
Well, I think that what I set forth in my brief regarding ambiguity of the statute, I think that the statute is ambiguous by virtue of the fact that nowhere in RPAPL does do legal fees.
You know that under the American rule, you don't get to an award of counsel fees on an ambiguity in a statute.
No, Your Honor. What I'm suggesting to Your Honor is that the court has already implied fees into RPAPL 881. What I am and as a result, and this goes beyond the American rule because Penn Asian Estates did say that what we're talking about here is not a denial of access and not a refusal, but it is, and not incidents of litigation, but it is legal fees incurred in negotiating a license. And that's what we have here. And I don't believe that anything in RPAPL, it would be inconsistent with RPAPL 881 that has already implied fees to be able to grant them as justice requires in the case where the neighboring property prevails.
I mean, the judge in Kings County specifically said, and acknowledged that it was somewhat counterintuitively, if a respondent, that's you, is successful in opposing an 881 petition and no license is granted, then that respondent would not be entitled to attorney's fees for successfully opposing the petition.
That is very true, Your Honor, and that is exactly why I asked.
That's what happened here.
Yes, that is exactly why I'm asking this court. This is an issue of first impression in the appellate division. I'm asking this court to overrule that Supreme Court and the Supreme Court below that, that held on this counterintuitiveness. Now, I would like to point out in Panasia Estate, a case that was decided in February of this year, that the language used by Your Honors was that it's a compulsory licensor that should be entitled to a reasonable attorney's fees and engineering fees. I think that that's important. That's an important distinction because had petitioner appellee done everything right, had they given plans that properly protected my client's foundation and my client's roof, my client is a compulsory licensor if everything's done right. The case law just simply says that you do not have to give a license if your building is going to be in danger. And it would be counter, and Panasia also discusses the purpose of RPAPL 881, which is to strike a balance between petitioner's interest and the harm to the adjoining property. It doesn't say anything about prevailing on the 881 petition. And I think that the language of RPAPL 881 itself is consistent with the prior holdings that attorney's fees can be awardable when, an adjoining property would be successful in fending off a petition. The purpose of the statute is to protect the neighboring property. They haven't asked for this. If we held
Well,
other...
you got your, I mean, you won. The judge found that you were correct. Nobody appealed that issue.
Understood, but my client had to go out of pocket thousands and thousands of dollars of fees because of damage that was possible to their foundation, and the purpose of the statute to protect the neighboring property and not to incur costs should extend to a situation where the respondent in the underlying action actually wins. Your Honors, I see my red light is on.
Why don't we
If you
hear
have
from
any more-
respondent? You'll have a couple minutes to respond, to rebut that. Okay?
Good afternoon, Your Honors, and may it please the Court. My name is David Pereno. I am counsel for Petitioner Respondent 419 BR Partners, LLC. This Court should affirm the lower court's decision to deny legal and professional fees for 3 reasons. Number 1 is the plain wording of RPAPL 881. Number 2 is case law from this Court interpreting RPAPL 881. And 3 is public policy. Now, starting with my first point, which is the plain wording of RPAPL 881.
Well, isn't it, as Justice, my co-justice,
Judge Katzman. Yeah, that's what.
Isn't it really counterintuitive? He wins, so he doesn't get attorney's fees. He loses, he gets attorney's fees?
Your Honor, that is the standard that's before the court. I actually don't think it's counterintuitive, though. If you look at what the court said in matter of Pan-Asia just recently, I think it was this past February, what the court's looking at is to balance the equities. That's actually what this court has said the purpose of 881 is. And in justifying giving fees to a respondent in that proceeding, what they look at is the harm that they face from having substantial and intrusive access to their property.
But ordinarily, the fees go to the winner, right? To the prevailing party, right?
In situations, Your Honor, where fees are given, sure. But in this case, there is no...
But see, he's in a situation where his property is being invaded and possibly, he claims, being damaged. And so he has to protect it.
So, Your Honor, that's exactly the distinction that I'd like to make. Because the license was denied here, there is no invasion into the property.
You can't do the underpinning or any of the other work until you provide more information to the defendant, perhaps make another request under RPAPL 881 and get it granted. You can't do this work now, right?
That's absolutely correct.
So you can't put something over his roof, you can't underpin under his building.
That's absolutely correct. What Pan-Asia looked at, what DDG Warrant looked at, what matter of Van Doren Holdings looked at, it all talks about, well, the person that's compelled to grant a license has a harm that's against them. We're going to balance out that harm by awarding them their attorney's fees.
And licensing, and are there architectural fees or licensing fees or some other fees they get also?
That's correct, Your Honor.
But there's no provision, if you don't do the work, so the counterintuitive or whatever strange thing is, they've kind of won the case, but they can't get legal fees. If they lost the case, they would get like a licensing and attorney's fees.
That's correct, Your Honor. What the statute says is such a license shall be granted upon such terms as justice requires. It does not say shall be granted or denied upon such.
It's when the license is granted, we deal with the fees.
100%, Your Honor. That's exactly
And
correct.
there has to be a statute, a rule, or a contract provision that allows attorney's fees, otherwise...
That's exactly what the American rule is, Your Honor. That's what we set forth. And that's what, frankly, is consistent across every case that we've looked at. Every case that this court has looked at, every time, I believe it's just 3. And then the matter of North 7-8 versus Newgarden case, which Justice Said had determined and to which this court has cited over and over again, have all held that. And that is a precedent that should not be abrogated here. Just one final point, Your Honors. I think that from a public policy perspective, it might seem like it's this counterintuitive or inequitable result. I actually think that it would be dangerous to award fees here. You have to keep in mind that these are neighbors that are next to construction projects. There is no shortage of neighbors in New York City that does not want an active construction project next to them. In fact, I'd wager that it's every neighbor to every construction project. If you give fees here where the license is denied, then you'd be encouraging people to fight. Because win or lose, you get the license, you're going to get your fees. You don't get the license, you're going to get your fees. It would encourage fights, it would encourage litigations, and it would frankly discourage the way that I personally work out 99.9% of these things, which is through active negotiations and coming to reasonable terms that work for everyone.
Including payment of some types of fees.
Including payment of yes, legal and professional fees. And for those reasons, we respectfully request that Your Honors affirm the lower court's decision. If you have no more further questions for me, I rest on the papers.
Perfect timing.
Thank you.
Mr. Perrano said it perfectly, except in the reverse, that to hold that the neighboring property should not be allowed fees would encourage more litigation, it would encourage more strong-arming, it would encourage the failure of developers who are the more moneyed people to hold out until they can impose their will on a neighboring property. Panacea Estate recognized that specifically by saying what the developer seeks essentially was to compel the neighboring property to grant a license on its own terms. And that's exactly what's happened here. That's exactly what fees, when a license is denied, is designed to prevent. It should be designed to make the developer give appropriate legal plans to a neighboring property and not require them to have to go to court and say, hey, my building's going to fall down if this person is allowed to do exactly what they said they were going to do. Justice Saunders found that. She said that, that it needs to be definite. It was not. It said that my client did not refuse access. She also held that our professional engineer said that their plans were insufficient and that was credible. Now, I do want to address Mr. Perrano's other point with regard to the language of the statute, because he left out some very important words. It says, such cases shall be granted by the court in an appropriate case upon such terms as justice requires. So, the court is empowered to deny a license when it's an inappropriate case. And based on the other clause, it is empowered to impose conditions as justice requires, including legal fees, which is the basis for legal fees when a developer wins. If you have no further questions.
I think we got the point. We'll take a look. Thank you both very much.
Thank you. We'll rest on our briefs.